Hello everyone, this is Urvashi Chauhan. Welcome back to Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. The Supreme Court has refused to entertain the writ petition by transgender activist Ms. Malem Thongam, who sought quashing of the FIRs registered against her. The FIRs were registered for her fasting until death to protest against the ongoing Manipur crisis. Ms. Thongam has been fasting unto death since February 27th this year. It was alleged that she was causing enmity between different tribes and attempting suicide on 12th March. However, on both occasions when FIRs were filed, the trial court had granted her bail. She claimed that Imphal police repeatedly picked her up from the place of protest and forcibly admitted her to the hospital. In her prayer before the Supreme Court, she had sought clubbing of the FIRs and quashing them. But the bench comprising CJI Chandrachud, Justices J.B. Pardiwala and Manoj Mishra declined to interfere in the matter, observing that it would be pertinent to first approach the High Court. The Supreme Court has expressed serious concern over misuse of social media platforms where factually incorrect and unfounded statements are made regarding cases which are sub judice. A bench of Justices Aniruddh Bose and Bela Trivedi was dealing with a case which involves a dispute over the 2021 election result of the Sonai Legislative Assembly seat in Assam. The election of the winning candidate, Karim Uddin Barbuya, a leader from the All India United Democratic Front, was challenged by the defeated BJP candidate. Barbuya on 20th March published a Facebook post that the court had favored his case, when in fact the matter was only reserved for judgment on that day. Taking note of the Facebook post, the court initiated contempt proceedings against him for misleading the public about the court. The court also expressed displeasure at the recent trends of misusing social media platforms under the garb of right to freedom of expression to tarnish the integrity of the court and misinform the masses. The Kerala High Court today dismissed the election petition moved by CPIM leader and former MLA M. Swaraj challenging the election of Congress candidate K. Babu from the Tripunirithura constituency. Justice P.G. Ajit Kumar dismissed the petition moved by Swaraj, alleging that the election was vitiated by corrupt practices under the Representation of People Act for allegedly making appeals in the name of Lord Sabrimala Ayyappa. The election petition specifically alleged that approximately 70% of the voters in Tripuntura are believers of Lord Sabrimala Ayyappa. Considering this, the respondent appealed to several voters to vote for him in the name of Lord Ayyappa and said that failure to vote for him would cause displeasure to the Lord. Also, let me tell you, recently the Supreme Court had dismissed the petition filed by K. Babu challenging the maintainability of this election petition filed by Swaraj in the Kerala High Court challenging Babu's election. For more details on this matter, do visit livelaw.in. The Privilege Committee of Bar Council of Punjab and Haryana has summoned the chairpersons of HDFC, ICICI and Axis banks for allegedly asking their panel lawyers to pay the court fees for filing cases in the Debt Recovery Tribunal, Chandigarh. The court noted that fees runs into lakhs and the banks are set to reimburse the same only after months. A complaint was actually made to the council by the Debt Recovery Tribunal Bar Association Chandigarh requesting to take action against the banks to stop the unethical practice. The DRT Bar Association alleges that the court fee being excessively high, which ordinary lawyers cannot afford to pay. They have further stated that the banks or its officers have no power to ask their empaneled advocates to pay the court fee from their own pocket for filing the cases in Debt Recovery Tribunal, Chandigarh. The Privilege Committee observed that prima facie this kind of practice, if it is prevalent, is certainly in violation of the provisions of Advocate Act of 1961 against privileges, rights and duties of the advocates and also against the interest of common advocates, particularly the young advocates. In light of this, the committee has now summoned the chairpersons of the three banks. It said that non-cooperation of the order will lead to interference, that unethical practice is going on and will be an admission calling for further action in accordance with law. In another update, the Delhi High Court has observed that Protection of Women from Domestic Violence Act of 2005 is a measure of social justice applicable to each woman irrespective of religious affiliation or social background. Justice Anup Kumar Mendrata said that the statute was enacted to safeguard the rights of the victims of domestic violence in domestic relationship. With this, the court dismissed a plea moved by a husband and his relatives challenging a trial court order restoring the domestic violence complaint of the wife. Lastly, the Allahabad High Court has observed that people in India are free to choose and change their religion. However, such changes must adhere to legal procedures. A bench of Justice Prashant Kumar was dealing with a Section 482 plea moved by a couple where the husband is a Muslim and the wife is a Hindu. The plea seeks to quash an FIR lodged against the husband in the year 2016 under IPC for the offence of kidnapping, rape, and under the POCSO Act. The defence argued in court that the girl, who is claimed to be the victim, willingly married the man and converted from Hinduism to Islam. That she stated in her official statement that she gave birth to a daughter, naming the man as the father. Therefore, it was contended that there was no evidence to support the alleged offence. The court, while stressing that in India it is open for anybody to change their religion, but merely an oral or written declaration does not constitute conversion, it directed the counsel appearing for the state to verify that the conversion in this case was not done to overreach the legal hurdles or under any pressure or greed, and also to ascertain the facts whether the conversion was just for the sake of marriage. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.